Varying a contract. I've already talked about the rules around terminating an offer and the effect of a counter-offer on a preceding offer. But what happens when parties to a contract are no longer content with the bargain which they have struck and want to alter it? The general rule is that anything in a contract can be varied by agreement between the parties. A contract may specify the way in which a variation must be reached, for example a change control procedure to ensure that changes to complicated contracts are evaluated and documented correctly. But even these terms can be varied by agreement. Variation of a contract is, in itself, an agreement, and so should, logically, require consideration. However, consider the case of Williams and Brophy, in which the client agreed to vary the contract with the carpenter, paying the carpenter more for doing the same job to avoid a slipping timescale. As I discussed in the previous podcast, finding consideration flowing from the client in this case is difficult, and the court had to engage in what might, not unreasonably, be seen as logical gymnastics to find a solution which appeared to fit the problem. Where the variation benefits both sides, consideration can be found quite easily. See the W.J. Allen case. As such, it's arguable whether consideration is required in practice, although from a pure doctrinal perspective, it clearly is. In some contexts, it is particularly clear, for example the case of a debt, and there are special rules around debt in which a party owed money cannot accept a lesser sum of money in payment of a debt now due. See Pinnell's case and Folks and Beer. However, this principle has been criticised on the basis that while a lesser sum of money cannot be accepted in full satisfaction of a debt, something which is not money, and which is of token value, does suffice. See Coldry and Bartram. So far, what I have discussed has been bilateral variation, variation which is expressly agreed by both parties to a contract. But what happens if just one party wants to change the terms of an agreement? Unilateral variation. Generally speaking, one party trying to change the terms of an agreement is ineffective, as a change of terms is in itself an agreement. If the parties do not agree to the change, there is, obviously, no agreement. However, some contracts include within them terms which permit one party to make a change simply by giving the other party notice. Is such a term effective? It depends perhaps on how the terms are drafted. A term which permitted any form of variation may be void for lack of certainty. One might also attempt to argue that the change is without consideration and thus unenforceable. Indeed, much play could be had with an argument that the only type of contract which is likely to contain such a clause is one where the bargaining position of the two parties is not equal. Who would agree to a contract in which a core term such as price could be modified simply on notice without requiring their express agreement? In a business-to-business relationship, one might be more willing to concede that parties should be able to contract on whatever basis they wish, but where one of the parties is a consumer, unless the clause permits only changes in the consumer's favour or changes originated by the consumer, it's hard to see how such a term does not represent an abuse of power. Of course, if you represent a party seeking to enforce such a term, you're likely to make all sorts of arguments as to why the term is perfectly fair and reasonable. For example, that there is no change in the agreement to the bargain between the parties, as the parties have pre-agreed a term which permitted a shift in price, and the party's right under that term was simply being exercised. The contractual term, the right to modify the price, remains unchanged. Else, you might argue that the right to change the price recognises the volatile situation in which the supplier finds itself, and that, faced with potentially significant fluctuations in cost, the supplier can either offer the services at one price and adjust it in the event of an increase, or else it would have to price its services so much higher to begin with to take into account the risks that prices rise. This would mean that by offering the service at a lower price and permitting an increase if costs should go up, the supplier offers the customer a better deal than simply charging a higher price up front. This is an issue which was faced by the UK telecommunications industry recently, over the extent to which a communications provider should be permitted to implement in-contract price rises, changes to the price which a subscriber to a post-pay airtime agreement pays for their service. For a number of years, providers considered that they had the right to adjust the price each year. While it's perhaps understandable that if you sign up to a service at £10 per month for a period of 18 months, you expect the price to remain at £10 a month for that duration. However, what about a change to the price of other services, not to the price of the core bundle? For example, international calls are often out-of-bundle services. Is an operator required to say to a customer at point of sale, "Here is a list of prices for international calls," and these cannot change for the initial term of the customer's agreement? Or should it be that since these are extra services, which the customer can use outside the bundle but has no obligation to use, it's fair to let the provider change the prices for them? For example, if an international destination changes its termination rate, should the operator be able to update its prices accordingly? In the UK, this has turned particularly on the meaning of the phrase material detriment within the General Conditions of Entitlement, General Condition 9.6. Although Ofcom had allowed a degree of variation, by which we mean increase, in price previously, it has revised its position in guidance issued in 2014, stating that Ofcom is likely to treat any increase in price to the agreed core subscription price during the fixed term of a telecommunications contract as a modification that is of or is likely to be of material detriment. So this is a change to the core bundle, not a change to services which a customer can also buy, such as out-of-bundle international call pricing. I move now to talk about assignment and novation, two methods for changing the parties to a contract. Under assignment, one can only assign the benefit of a contract. The burden of the contract, a party's obligations, cannot be assigned to another party. This means that in the case of assignment, the benefit of the contract moves to another party, but the original party remains responsible as a matter of contract law for its obligations. In practice, it is likely that the assignee, the person who acquires the benefit of the contract, takes over the performance of the contractual obligations too and indemnifies the assignor against breach. Under novation, the burden of the contract can be passed to another party as well as the benefit. This is because a novation extinguishes the first contract and creates a new one under which the third party takes up the rights and the duties of the original party. Novation requires the consent of both of the original parties to the contract as well as the new incoming party, and requires consideration. Although, as with other circumstances, if mutual benefit can be found from the change, consideration may, in practice, be a non-issue. As I discussed in the podcast on privity, the recognition in 1999 of rights of third parties under the Contract Rights of Third Parties Act has changed the position somewhat in respect of variation of contracts where there is benefit to the third party. The rules are contained within Section 2 of the Act, else do listen to the podcast again to remind yourself of the rules. To summarise, parties to an agreement can agree to vary its term, and, as with any agreement intended to have binding legal effect, such a change will need to be backed with consideration, although, in practice, a court may be minded to find consideration in a mutually beneficial variation. Unilateral variation may be possible in some circumstances, although the extent to which this is going to be upheld by a court is somewhat questionable. And lastly, I talked about the notions of assignment and novation, of means of moving the benefit of a contract under assignment and both the benefit and burden of a contract under novation from one party to another.